Well, thank you very much for the very innovative and cutting-edge introduction. As was mentioned before on the slide, I'm usually working as a lawyer and a lecturer for intellectual property law, meaning that I, in general, attend law conferences. So this was a first for me. Also, this entire technical equipment is novel and not something you usually see at a law conference. What we're doing today is we're going to talk a bit about the terms of NFTs and the metaverse from a legal perspective. And I'm assuming that no one here is busy in the field of law or anything. Great. So we're all going to learn something. And so we're also going to look at it from a legal perspective, naturally. And bear with me. Technology and law, it's kind of an interesting dynamic relationship because law is, in general, like essentially 2 or 3 steps behind most of the time. That's why we're just talking now about NFTs because our clients just now discovered NFTs for themselves, and naturally they are interested in giving them a more legally sound framework, and this is what we're going to talk about today. Essentially, the agenda for today is there are 3 steps. First, we're going to talk about the NFT itself for a bit, in the sense that asking and answering a question, what is an NFT technically, identifying those technical elements that are legally relevant. Then we're talking a bit about the law. This is going to be very short, just to answer the question, what is an NFT legally? And finally, the issues that arise from the combination, answering the question, what is an NFT really? What is the purpose? What are the issues that we are dealing with as of now? Why are we as lawyers talking about NFTs at all in the first place? It seemed at the beginning that this was more of a niche kind of crypto asset system. However, the answer is pretty easy. There's a lot of money in it. And once there's a lot of money in it, lawyers naturally can become involved quite intensely. And what we have here is one of the examples where NFTs were sort of hailed as the revolutionary item for the digital arts market. And as you can see in this certain project, there was the idea that everyone, especially digital artists, were now able to commercialize their digital art in an entirely new way. So this was the first approach that we had, and the first element that led to the legal significance of NFTs. But then on the other hand, we had something like this. And you probably heard about this case. This is the first tweet of the then CEO of then Twitter. And he has he minted an NFT of his tweet and sold it for $2.9 million. And the idea was, from the buyer then back in 2021, he intended to use this asset as an investment strategy, and he intended to resell it for $48 million. By a show of hands, who thinks that went well? And who thinks that went bad? And who thinks that went really bad? And that's actually what happened. The highest offer he got was $250,000 to $32,000, depending on the platform used. So again, this is another issue that arises. Investment opportunities are usually advertised. Once you advertise something, there's a lot of law involved, a lot of legal issues that arise. That's why there's now just recently a very famous lawsuit was started against a whole variety of people in the public area advertising NFTs as investment opportunities, and all of the respective statements that were made are now subject to legal scrutiny. To understand why NFTs have become so relevant from a more legal perspective, this was more of the aspect regarding the financial relevance. We have to look at blockchain technology just a tiny bit to understand why you would build something on blockchain technology. One reason of blockchain technology was to get rid of us, lawyers, and the legal system, because the idea of the blockchain technology, the decentralized system of transaction and using a decentralized ledger, was to abolish the trusted third party. And being a lawyer, judges, and all of that, those are trusted third parties. Because, for example, if you enter a contract, you rely on the legal system to enforce the contract in case the other party doesn't perform. The blockchain technology, at least to a certain extent, was intended to get rid of that, just have two parties working with the code, the blockchain, as the central institution. The idea, the most technically relevant element here is the immutability of the blockchain, meaning that it can't be changed after the fact, being essentially a ledger that is safe for all future transactions and also a proof for all past transactions. The NFT itself was intended to solve this problem. You were faced with the issue in the digital world that everything is copyable to a 100% degree of similarity, meaning that it is difficult to identify, if not impossible to identify it, and a digital original. And without originals, you can't really have an art market or an art collector's market, because the value of the original is always much higher than the copy. So NFTs were intended to function as digital certificate of authenticity, providing uniqueness to a world that is inherently hostile to a unique device, because you have the probability and possibility to copy everything, meaning that there's no way of differentiating the copy from the original. We're just going to go over the relevant technical issues specifically for the blockchain. I'm assuming you are all much more versed in that technology than I am. So I'm just going to give you the points that we have identified as being mostly relevant for our legal analysis. We have the instrument to ensure the immutability of these blocks is just uses the concept of hash values that are incorporated from one block to the next, meaning that it is impossible to change one block after the fact without making the entire chain inoperable, thereby proving a certain manipulation after the fact. The entire thing is used through a key system. You have a public key, which is essentially the address of your wallet, and then you have the private key or the private keys, which are used to transfer one block or part of a block to another address, and both of them are stored in the wallet, meaning they are written down, essentially written down on a piece of paper, for example. That would be cold storage, or you have something online, and then you have a classic crypto asset wallet. And here's the first issue from a legal perspective, because in the world of crypto assets, access equals ownership. The person who has access to crypto assets is considered the owner. From a crypto perspective, however, in the legal sense, that doesn't work, because ownership is a very specific legal concept, and access itself is not enough, usually. Also, the blockchain technology has no way of identifying unlawful access. Unlawful and lawful access is, from a crypto perspective, identical. From a legal perspective, naturally, it is different, because one is lawful and considered valid, or the other access is not considered valid or is considered to be invalid. And the second problem that we have is that the transfer of a key is also a transfer of the blockchain asset. So you don't really have to use the blockchain technology to transfer the asset. You can just transfer the key by just handing it to someone else, and by gaining access through that transfer, he's also gaining ownership from a crypto perspective of the asset, meaning that you now have a transfer that is not recorded on the blockchain. Now you might argue that from a crypto perspective, that's insane, because who would do that? Who would trust someone that the private key that is handed to you is actually the working key? And how do you know that he's not keeping a key for himself? Right, that would be another issue. However, and finally, that raises the question: by doing that, doesn't the whole concept of crypto fall apart? And the answer is yes, it does. And when you're asking who would do such a thing, the answer is that we do, the lawyers and state and district attorneys. For example, what we have here is an auction of 1 Bitcoin that was seized in the raid from the district attorney's office in Cologne. And I don't know if you can read that either because it's in German or it's too small, but the relevant part is that the successful person who offers the highest bid for this Bitcoin, he is going to have this asset transferred by handover of the paper wallet, including the private key necessary for further transfers, meaning you're just getting a piece of paper with the key on it, which again is not recorded on the blockchain itself, and therefore kind of goes against the inherent system that Bitcoin was intended to solve. You are also able to use the actual blockchain transfer mechanism if you so choose. However, then the state's office requires you to pay the transaction fee. And so most people just choose to have the paper wallet transferred. To ensure the uniqueness of each of these steps, we have the hash function. I'm assuming that, again, you're much more versed in this than I am. The idea is essentially to reduce a huge amount of information into a smaller amount of information, and to just use that as sort of a digital fingerprint that allows you to identify whether an object or a digital item has been changed after the fact. There are certain properties that are necessary to achieve this hash function. I don't think that's necessary to go through all of those from like a legal perspective. We're just going to take a look at the NFT itself. Now that we've talked about the issues that arise from blockchain technology itself, the NFT, on the other hand, is unique and non-divisible, meaning that it is minted. You can only have one NFT at a time, and you can't change part of it. You can't transfer part of it, other than with conventional blockchain assets such as coins. You can easily just transfer part of a coin, and all the coins are interchangeable. The idea was essentially we have now a unique digital item, and by linking that to a non-blockchain asset, we can have a unique digital item. And that was the goal. The problem is, how do we link the digital asset to an NFT? And the problem, of course, is we can always have a new NFT of anything. There is no way to ensure that there's only one unique process of minting. You can have multiple NFTs of the same thing, meaning that's also going to issue legal problems. And now that we've talked about the technology, just going to go very briefly over how the law has dealt with NFTs in the past, or let's say for the last couple of years. The idea first came to mind is that is an NFT property in the sense of the law. The problem with that is that the law, at least in most jurisdictions, only recognizes tangible objects, so nothing digital. You can't own anything that is purely digital. The next idea was to consider it a right. Is an NFT a right to something or of something? The issue with that is that a right, from a legal perspective, needs to have a direction. You need to have the right against someone or against something. However, since there is no centralized institution that administrates the results of NFT minting and processes, so there's also nothing you can do about that. Finally, data rights. The issue of that is that from a legal perspective, you can't own data, meaning this doesn't work as well. So as of now, NFTs are just considered to be subject to generic service contracts that you're essentially, when you're buying an NFT, you're essentially buying from someone the possibility to gain access to the mechanisms that allow you to transfer the certain NFT, meaning that it is not really virtual property from a legal perspective because no such thing exists in most legal jurisdictions. And that brings us to the issues. And one central issue of the NFT technology and essentially the entire framework that exists is the attitude. And I've chosen this tweet to illustrate the most relevant issues that we have from a legal perspective, because as you can see, this is clearly talking about assets which are, from a legal perspective, recognized. It is also interesting to choose a fire to destroy a diamond, which is also technically difficult. And finally, we have the last element, which is going to talk about the difficulty of explaining the NFT technology, NFT value to someone else, because as is pointed out here, if you don't understand it or if you don't get it, then you're just not part of the community. This is also making NFT legal jurisprudence pretty difficult. I'm going to talk quickly about the issues that we have from an IP perspective regarding the unique item. What we have here is the NFT and the asset. We're trying to link that to a certain degree. What can we do to achieve that? We could copy all the data of the asset into the NFT. Those are so-called on-chain NFTs. The issues with that is that NFTs have to be, from a data perspective, rather small to be practically usable. Otherwise, the transaction calculation costs and efforts rise exponentially. And the second problem is that to get the asset into the block, we need to copy it, and thereby we would kind of circumvent the entire problem of keeping it at an original. So the practical solution has been, we're just going to put a URL into the NFT, and that links to the asset, a link to a picture. The issue with that is, from an IT perspective, most of you are likely to know that the URL stands for Uniform Resource Locator, meaning that the resource is not in the URL itself. And therefore, there's no technical link to the asset itself, just to the location, meaning that if someone changes the data that has been secured on that location, there is no way of changing the NFT afterwards because the link is essentially part of the immutability of the blockchain. And as I said before, you can't own data, you can't own a URL, so there is no ownership with that regard. And again, we'd have no way of confirming that's an original or not. So the whole entire thing relies on trust or a social assignment between the NFT and the asset. From a legal perspective, there's no link. So there's nothing that connects the NFT to the asset, making it difficult from a legal advising perspective to just issue NFTs in that respect. We have, for example, this is an NFT in IP law case that we at White & Case are advising as of now. We have a very classic system. We have an NFT seller, a buyer, there's a digital asset, and we have an IP rights holder. So it's just someone who used a picture of someone else. The copyright holder is someone else than the person minting and selling the NFT. And now the IP rights holder wants to just target all of these parties and tell them to stop doing that. The problem with that is that we don't know which IP rights are actually violated, again, because there is no link between the digital asset and the NFT. So selling the NFT from a legal perspective is perfectly fine because you're not technically using the issue of the copyright protected work. And the second case that we have, these are just adjusted a bit because we have to keep attorney-client privilege. What we have here is a seat from a football stadium. This is a physical item. And what we have here is something that the football club told us is a unique digital item. And there's also an NFT involved. So what the project was intended to do, you were allowed to buy the old seats from a football stadium, and by purchasing one physical item, you're automatically getting a unique digital item, and that is linked with an NFT to certify the authenticity of the digital item. The problem number one was, how is the digital item unique? As I've said before, it could easily be copied. How do you ensure that it is unique? And if it is a certificate of authenticity, we need someone who certifies something, and there is a way of how to certify it. This is just a brief overview of what the terms and conditions look like, because of course, from a legal perspective, we had to design the terms and conditions. And as you can see, there are all sorts of issues. We have the aspect that the seat shell is a digital seat, meaning that it is a unique digital asset, and that just leads us to the same questions again. If you advertise something as a certificate of authenticity, then from a legal perspective, you also have a process of certifying said authenticity. So these are just the most current issues in IP law from NFT regarding NFTs. And just to give an overview of the metaverse, as I said in the beginning, the metaverse is heavily reliant on NFTs. The problem from a legal perspective that we have is that there's, as of now, no practical definition of what the metaverse is. There's no clear distinction of what the metaverse is versus the general internet. And we have had online platforms with avatars for quite some time. The issues that arose then arise now as well. If you employ it in VR or in AR, doesn't really change anything. Of course, NFTs are involved. As a last example, the concepts of those projects are often misleading. For example, if you look at Decentraland, the idea to have a decentralized world where there are certain plots of land to buy and transfer, that of course raises the issue whether it is really a decentralized system if the amount of plots of land is artificially limited by a central agency, thereby going directly against the name. So I'll just conclude with these key takeaways. The metaverse, as of now, it's all talk and no product. We don't have digital originals from a legal perspective. There is no legal or technical link between the NFT and the asset. We don't prove ownership from a legal perspective, but rather access. And finally, if you want to involve NFTs in anything, you have to be really careful about drafting contracts, because you don't want to make yourself liable by choosing a certain wording that has a specific legal meaning, and that is not respective in the concept of the NFT itself. And I'll just conclude with that, leading to the Q&A.